SK Lansing Limited versus Benito Fombi, 25-05900. Finance, please. Happened to thing that I can't say. Beards, please.
Good morning, Your Honor. Attorney Sean Mock for the plaintiff.
Your name, ma'am?
Benito Fombi.
Okay, today was the date that was scheduled for a hearing. For non-payment of rent to the parties. I'll work this matter out at this time.
Well, Your Honor, we've reached an interim agreement. Ultimately, we're requesting an adjournment for 30 days. We have been trying to resolve some maintenance issues for a long time with respect to this property. With both parties' cooperation this morning, we've reached an agreement concerning those repairs. I would just like to place that agreement on the record, Your Honor. The landlord has agreed at its expense to book suitable accessible accommodations out of several options that have been identified by Ms. Fombi. She will be housed there for approximately 2 weeks while certain repairs are completed to the living room and bathroom of the unit. And then at our next court date, we'll come back to address the past due rent after the repairs are completed, Your Honor. And we've agreed to provide Ms. Fombi at least 1 week's notice in advance of the repairs starting.
Okay, so there's some repairs that need to be done to the living room and the bathroom. And how long has it been since these repairs needed to be done? I think the last time I saw her, which was about a month ago today, she said her ceiling was caving in and that there was mold. Is that the issues that are being addressed?
Yes.
Okay. And ma'am, how long have you had this issue?
The mold man has been several years in the ceiling, I would say, I'm thinking actually probably 6 months.
Ceiling caving for 6 months?
Yeah.
Okay, and so you want 30 days and then you'll come back and try to wrap this up.
Yes, Your Honor.
February 11th at 8:30.
And sorry, Your Honor, we've had many communications with the parties trying to coordinate on the repairs. For whatever reason, they've been unable to coordinate access, unable to coordinate alternate accommodations. So I want to be clear for the record that the landlord has not ignored these repair issues.
Okay, if that's something issue, we can delve into that more, I guess, at the next court date. I don't know how it goes years with mold and 6 months of your ceiling caving in and the landlord does not get access. I don't know how that works because all they have to do is give notice and then they can gain access to the property.
Your Honor, we'll be happy to address that at the next hearing if it becomes necessary.
Okay, sounds good. So we'll continue to February 11th.
8:30.
At 8:30 in the morning, we'll get you, I think you just got your notice to appear. Any additional matters for the record?
No, Your Honor, thank you.
Thank you. You're all set. Thank you. Edward Rose Associates versus Thomas Starwell and Iwa Kaweka, 25-06407. Please.
Good morning, Your Honor. Attorney Robert Acton, covering for Richard Herman on this matter.
And you are Thomas Stoll,
Yes, ma'am.
and your name is Iwa Kaweka? Okay, today was the day scheduled for hearing. This is for non-payment of rent. I do, however, have a landlord tenant judgment. States here that the parties are entering judgment by consent, correct? And that you agree that the past due rent to retain possession plus court costs are due in the amount of $7,249.23, that you'll either pay that amount in full or vacate the property of 4033-21 West Jolly in Lansing no later than the 20th of January 2026. Is that correct? Okay, you both have the right to be represented by an attorney. You understand that, right? Is that a yes, sir? Okay, and did you both want to give up the right to an attorney today? Or did you want to hire an attorney to represent you?
No, we're fine.
Okay, you also have the right to have a trial. You could have made a demand for a jury trial. Did you understand that?
Yes,
Do you want to waive your right to trial and have this case resolved by this consent judgment?
yes,
No one's threatening you to do this, correct?
no, ma'am.
No promises if you enter a consent judgment?
No.
You have 3 business days from today's date to return to the court. If once you leave here, you realize you in fact misunderstood those rights we just went over, you can return to the court, request to have the judgment set aside, and then we'll set up for a hearing for you to explain to the court how you misunderstood your rights, okay? Any additional matters for the record?
No, Your Honor, thank you.
We'll get you a copy of the report. Coronado Gardens versus Amber Perez, 25-06408. None of those people are here?
Oh, yeah, they were still trying to negotiate.
It's an hour. It's been an hour.
Yeah, we go.
If you can't figure it out an hour, you just need a hearing. Which matter are you here for, counsel?
I am here for,
South Washington Park versus Terrence Jackson, 25-06426. Appear.
Good morning again, Your Honor. Attorney Sean Mock, P78785 for the plaintiff.
and good morning, Your Honor, Sir Oliver, P87707 for the defense.
Okay, today is the date that was scheduled for hearing. This is for termination of tenancy. And my understanding is there was a request to adjourn. No?
We have a pending request for discovery.
This is Jackson.
And the plaintiff is willing to stipulate to an adjournment for the purposes of conducting some limited discovery. I think the issue is how limited of scope the discovery should be permitted. The plaintiff would be agreeable to allowing up to 10 interrogatories and requests for production. This is really not a complicated issue. There's video footage of the defendant dropping keys to a third party. That third party enters the apartment complex, and upon leaving the apartment complex, the third party gets into an altercation with security and shots are fired. So the issues in this case aren't that complex. We are agreeable to discovery, but we request that discovery be limited, Your Honor.
What are you seeking, counsel?
Yes, we're not seeking that type of limited discovery. We're seeking 30 days of written discovery with the maximum amount of interrogatories allowed. We don't anticipate that we would have to do that, but we were just given notice yesterday afternoon about exactly what this was about, because the complaint did not provide any notice, just like the statute. So we are still actively figuring out what exactly the allegations are. We don't have any notice about the dates of the incident, who this individual was, police reports, stuff like that. I don't agree that this is easy. I think that this is a complicated situation with a third party that is unknown to my client. So I'm just not prepared to agree to that limited discovery at this point.
Okay, so it doesn't sound like you're sure at this point how much discovery you need.
Yes, we don't anticipate having to do the full 20 interrogatories that are provided under the rules, or more than 10 requests for production, but we just don't know at this point.
Have you received this video?
No.
Okay, maybe we can start there, and then that might help you figure out how you need to limit your scope, I guess, of discovery. And then if we need to make a motion to either expand or limit the discovery, then we can do that at a later time. So 30 days you're requesting, is that
Yes.
Yes, Your Honor. I do have an order to share the final.
Oh, yes.
February 11th at 8:30.
Any additional matters for the record?
Not for the plaintiff, Your Honor. Thank you.
Nothing for the, Your Honor. Thank
You're
you.
all set. Okay. Not regarding. On the record in the matter of National Eagle versus Lemmy Jones and Lamisha Jones. That's 5-06434. Appearance, please.
Good morning, Your Honor. Robert Oxley, the attorney for the plaintiff.
Hi, what's your name? Sharice Taylor. Okay, you're Sharice Taylor. Lemmy Jones and Lamisha Jones are not here, is that accurate?
And Your Honor, my plan, if it's okay with the court, was to submit a default against them with basically the same terms that were in that conditional dismissal. I think more beneficial to them than just the regular default. That makes sense to me to do.
Oh, okay, it looks like they failed to appear the first time too, but
That's my.
yeah, so, default could be entered against them. You said with the same terms as this?
Yes, and I was going to submit that on my file when I got back.
Okay, so, for, as it relates to Ms. Sharice Taylor, there is a consent order for conditional dismissal, so the matter will be dismissed today upon the condition, excuse me, that you pay the past due rent, $6,500 plus court costs, $215, a total $6,715. And that's for rent through the period ending in this month, January 31st, 2026. It says the defendant is to pay $3,500 on or before the 20th of January, 2026. The defendant is to pay February rent plus the balance of $3,215 on or before the 28th of February, 26th. That's accurate, ma'am?
Yes, ma'am.
Do you understand your right to be represented by an attorney?
Yes, ma'am.
Do you want to waive that right?
Yes.
You also have the right to proceed to trial in this matter. Do you want to have the trial or do you want to do the
We're going to go with that.
Okay, and no one's threatening you to enter into this agreement,
No,
correct?
ma'am.
Okay, partial performance will not satisfy this, so it says that here in this section, you gotta pay the full amount that you say you were gonna pay here on the dates or before the dates that you say you would. Otherwise, the plaintiff can request judgment to enter against you, and you will not receive a new court date for that, okay?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
You have 3 business days to return to the court. If you later realize you misunderstood the rights that you've given up, you can request to have this set aside, okay?
Yes, ma'am.
We'll get you a copy in just a moment. Thank you.
Thank you.
Thank you. Your Honor.
Thank you. Tima Khan versus Maddie Harris, 25-06585. Appearance, please.
Good morning, Your Honor. Attorney Sean Mock, P78785 with the plaintiff. I have not seen the defense this morning.
Did you want the fault to enter?
Yes,
Did you have experience?
I do, Your Honor. May I approach?
Yes. Thank you. All set. Look at your copy.
Thank you, Your Honor.
Bernardo Gardens versus Amber Perez, 25-06408. appearance, please.
I'm Amber Kate Perez.
And shown for plaintiff P69505. We have a partial agreement.
I'm sorry, can you speak up a little bit?
Yes, sorry. Marlena shown for the plaintiff P69505.
Thank you.
We have a partial agreement. We just, the only question before the court is how much time.
Okay, what do you have so far?
So Your Honor, this is a straightforward non-payment of rent case. It's possession only. There's no money judgment. We've agreed on the amount to retain possession only. Again, not a money judgment for possession only. 17,000 in arrears, 191.26 in cost. Total 17,191.26. The only issue before the court to decide is the amount of time to give to vacate. We're requesting 10 days since this is our fourth hearing. The defendant is requesting some extra time. We're just requesting a hearing judgment based on the amount of time.
Why do you think you can continue to hold over their property and not pay rent?
Well, I have not been working since last year.
Well, I'm sorry for your misfortune, but you can't just stay in someone's property for free. And we saw you first in November. It's 2 months later. I even granted a motion to set aside your previous agreement, giving you the additional time. At this point, I only have the right to give you 10 days. Really a little bit longer just because the 10th day is on a holiday, so you get 1 extra day. If they're not willing to give you additional time, I don't have the authority to do that just because you haven't been working. You can't hold over people's property and keep it for free. They have the right to get rent. And this is a large amount of money that's owed here, 17,000?
Yes, and again, that's just the amount to retain possession. There's no money judgment. I've made clear that the plaintiff may later try to sue to collect, but that issue is not at all before the court right now.
Right, so that they would file.
They have to file a whole other
Agreed.
suit.
Yeah, okay.
Yeah.
Agreed. So the best I can do is give you until the 20th.
Joanna, would you, may I approach?
Yes.
Okay, I've got the, I have a copy here.
Okay, so this is a consent judgment here.
Oh, wouldn't be a consent because we don't have a consent. So.
Oh, it's not a.
It's a hearing judgment on.
It's not a hearing because I didn't hold a hearing. You all agreed to that amount.
We've agreed to the amount only. We've not agreed to the move out date.
The move out date is per statute.
But the trouble is that if the judge is determining that she did not agree to that. If we enter into a consent judgment right now, that allows her the opportunity to again revoke her consent under the 3-day rule.
I was gonna go over that. She's not getting to revoke her. There's not gonna be another, I don't understand my rights under this for her, because she's already used that excuse on this. And so I was gonna go over her rights yet again. I had no discussion about how we got to the $17,191. This is a statutory amount, and I was gonna ask her if she's consenting to this because I'm not held a hearing. I just reiterated the law.
It's gonna go, I'm sorry.
Yeah, so it's up to you. Do you want to have a hearing today? You would like to resolve this today with a consent judgment?
I don't understand what that
So
means.
consent judgment means the judgment, this paperwork is going to be entered by consent, your consent, meaning you're going to waive your right to be represented by an attorney, that you will be willing to waive your right to have a trial, and that you are agreeing that you owe or would have to pay this amount, $17,191.26 to maintain the property or possession of the property, and you've got to pay that by January 20th or vacate by January 20th. So when I ask you, are you doing it by consent judgment? Are you agreeing to that, or do I need to have a hearing on this? Is what I'm asking.
I'm agreeing with you.
Okay, and no one's forcing you to do that, correct?
No,
No one's making any threats to you to make you enter into this by your consent?
no.
You don't feel coerced at all, do you?
No, no.
Okay, and you understand fully at this point your right to be represented by an attorney. You also understand fully your right to have had a trial on this matter, and you had the right to have demanded a jury trial within a certain time frame from your first hearing. You understand that?
Yes, ma'am.
And you've not done either of those things at this time, correct?
Yes, ma'am.
And so you're waiving both of those rights? Okay, and so you've not signed this, so I'm gonna have you sign this.
State, Your Honor, that if we're entering this as a consent judgment, I do have authority to give for a couple of extra days.
Okay.
So we could give you until the 22nd, which would be a day beyond Tuesday. Okay, okay, all right, so let me just change this date here to 22nd. Changes to consent, and since you are not represented by an attorney, you have the right to rescind this within 3 days, but the court has stated, and have to click that box and consent that.
She has the right to rescind it if she's able to determine on the record that she misunderstood her rights. Which, yes, at this point, she's gone over at least 3 times in this matter.
Okay. That the new date, Your Honor, would be the 23rd.
Thank you. So
Tuesday, 22nd.
22nd, so you're gonna pay that amount or vacate the property by the 22nd of January 2026, correct, ma'am? Get you a copy of the paperwork. Again, in order to have this rescinded within 3 business days, you would have to establish on the record that you misunderstood any of the rights that we've gone over. Do you have any concerns about the rights that we discussed? You fully understand those rights? Thank you. We'll get your copy before.
Thank you so much.
This is Todd Meisner versus Michael Edkey, 25-06761. Have appearances for the record, please.
Morning, Your Honor, may it please the court, Dominic Silvestri, P65275, appearing on behalf of the plaintiff.
Your name, sir?
Michael Edkey.
Okay, this is a hearing for a termination of tenancy. I do have a consent judgment here. It says that the defendant has the right to, plaintiff has the right to recover property, that the defendant will vacate the property no later than January 31st, 2026, correct?
Correct.
And that Mr. Headkey shall leave the home in broom swept clean condition. That's accurate?
Correct.
You understand your right to be represented by an attorney today, sir?
Yes.
You want to waive that right?
Yes.
You also have the right to demand a jury trial. You understand that?
Yes.
And you want to waive that as well?
Yes.
No one's threatening you to waive any of these rights, correct? No one's coercing you to enter into a consent judgment?
No.
You have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood the rights that you've given up, you can request to have that set aside, okay?
Okay.
We'll get you a copy. Any additional matters for the record?
No, thank you, Your Honor. Have a good day.
Thank you.
Thank you.
How are you? How are you? I'm here. Put you upstairs on a,
What was that?
put you upstairs on a Wednesday.
Nothing. Well, I was trying to get an order from our good friends down the hall here. but it's
Oh,
not-
okay, got it.
Hasn't been
I
made
was
in,
gonna
but
say, what's going on? I'm like,
figured I'd hop in.
what is this?
Default. I'm
A
sorry.
default judgment,
Oh,
Judge.
because it's not checked.
Oh, sorry.
Oh, I apologize.
No, wrong, what, Emmanuel Rowan?
Oh, okay, yeah.
Is that what that is? Venture Flats?
Yeah.
Yes.
Rowan.
Hey, Rollins.
May I approach this?
Yes. This is the matter of Waverly Park Place versus Shavante Wheeler and all other occupants. 25-06856, appearance please.
Thank you, Your Honor. Attorney Sean Mock, P78785 for the plaintiff.
What's your name, ma'am?
Shavante Wheeler.
Okay, Ms. Wheeler was scheduled today for hearing. This is for non-payment of rent. I have a consent judgment here. It says that the parties are going to enter consent judgment pass to rent to maintain possessions, $161.43. That's accurate. Is that accurate?
Oh, yes.
Okay, plus court cost $177 and 4 cents, correct?
Yeah.
For a total $338.47, and that you're gonna pay that or vacate the property by January 20th, correct?
Yes.
Okay, you understand that you have the right to be represented by an attorney today?
Yes.
You wanna waive that right? You know what that means?
No.
Okay, so you have the right to have an attorney represent you. You could have met with legal services at the time of your free trial to see if they could represent you for free, or you could hire an attorney.
Okay, yeah.
Do you want an attorney to represent you?
Yeah.
Okay, are you gonna hire an attorney?
No.
Okay, so how do you intend to have an attorney to represent you, ma'am? So you do not want an attorney, is what you're saying? Okay, you also have the right to have a trial on this. You could have demanded a jury trial, or you could hold a hearing on it. If you believe you had a lawful defense as to why you didn't pay all of the rent, okay? Did you want to waive your right to have that hearing and or trial?
No.
You want to have a hearing?
I'm just trying to just pay this off. I don't know.
Okay, so you do not want a hearing.
Okay.
That's what that means. If you want to just pay it off, it means you are not seeking to have a hearing, correct?
Okay, yeah.
Okay, and no one's threatening you to enter an agreement to just pay this off, correct?
No.
You have 3 business days from today's date to return to the court. If after you leave here, you realize you misunderstood the rights that we've gone over, you can request to have this set aside, okay?
Okay.
Do you have any questions?
No.
Any additional matters?
No, Your Honor. Thank you.
Thank you. Waverly Park, Waverly Place Apartments, that is versus Lynetta Homes and all other occupants in 25-06851. Yes, please.
Thank you, Your Honor. Attorney Sean Mock, P78785 for the plaintiff.
Your name, ma'am?
Lynetta Holmes.
Okay, you can just remain standing.
Yes, ma'am.
Okay, today's the date that was scheduled for hearing. This is for non-payment of rent. I do have a consent order for conditional dismissal. It states, ma'am, that you are agreeing to have this matter dismissed today with the conditions that you paid the past due rent plus court costs for a total of $1,554. That's for the rent accruing through the end of this month, correct?
Yeah.
And that you agree that you shall pay regular monthly rent, which is currently $470 per month.
Yes.
That by the 5th of each month under this agreement. Additionally, that you will pay an extra $518 on or before February 15th, March 15th, and April 15th to pay the amount down. That's $1,554, correct?
Yes, ma'am.
You have the right to be represented by an attorney. You understood that, right?
Yes, ma'am.
Are you waiving that right today?
I am reading.
You also have the right to have a trial or a hearing in this matter. Are you waiving that right? Is anyone coercing you to enter into this agreement? Is anyone threatening you or promising you anything to get you to waive these rights? You have 3 business days to return to the court if you later realize You misunderstood those rights, okay? Lastly, partial performance will not satisfy this agreement, so you gotta pay exactly what you say you were gonna pay, the amounts in on or before those dates, okay? If you don't, judgment can enter against you, and you could be evicted and you will not get a new hearing date for that, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Any additional matters, counsel?
No, Your Honor. Thank you for your time.
No problem, we'll get you a copy in just a moment.
Yeah. On the door. 10:30.
For Freeman.
Yeah.
I didn't know about.
Yeah, I understand.
Sounds good.
Oh, okay.
Let's see, Ali Boss versus Kurt Reed, 25-07066. Appearance, please. Your name again, sir?
Ali, Ali, Albas, ELBAS.
Thank you, and your name?
And Sierra Oliver, P87707 for the defendant.
Okay, today was the date scheduled for hearing. This is for non-payment of rent, and the parties are looking for additional time.
Yes, Your Honor. Mr. Reed has submitted an application for rental assistance through DHHS, and that application is still pending. So we have agreed to a 2-week adjournment to allow that application to process.
That's correct, sir? Yes,
Yes, I'm sorry.
that, they just have to hear you on the system.
Yes, it's okay.
Our next available is February 4th. February 4th is the next available date at 8:30. At 8:30.
So February 4th now?
February 4th is the next day.
Okay.
I will get your notice to appear. Any additional matters for the record?
Nothing further from me, Your Honor.
Thank you, Your Honor.
Thank you.
Have a great day.
Same to you.
Yeah.
That was Mr. Arthur.
Good.
Let's see. Mr. Akinick, did you have one? Or did we see Dakita Brown at all? Okay, we'll call the hall. If not, you can give me the call.
Get Brown. Oh, yeah. Okay.
Let's see who is in. Waiting a short reason.
I'll see you this afternoon.
Thank you. Have a good one. Lauren Spencer?
Yes, good morning.
Good morning. You're representing Stephanie Arms.
Yes, Your Honor.
Did you come to a resolution already?
We did, yes. I believe opposing counsel filed our settlement agreement yesterday.
Oh, did Mr. Bach know that? No.
You didn't tell us. No.
I don't think he knew that.
Oh, that they had a, let's see here.
I believe that there may have been 2 defendants. I was representing only Miss Arms. I'm not sure what opposing counsel was planning to do for the other defendant. I think they said that after my client moved out, they were going to dismiss the case against him because he is no longer living.
Mr. Bach is here now. Mr. Bach, you were aware that there was an agreement as to one party for the 1030 matter?
Yes.
Okay. And were we expecting Mr. Cutler, I think it is? Or it was your intention to dismiss against Cutler?
Says here, have a CD for her to vacate by 119. As the Cutler, we will dismiss as to Patrick if Miss Arms turns in all keys to the unit.
Got it. Okay. And
If not, we'll take default judgment against Patrick at the hearing.
Where is Miss Arms?
Your Honor, my sincerest apologies. This was my mistake. I forgot that in your courthouse that the defendant was supposed to be here, even if we had reached a settlement. She is not here today, but she has agreed to all of the terms.
I can't do anything if she's not here. She's got to be here to tell me that she agrees to the terms and that she understands her rights as well.
Okay.
So I don't know if you can get her to log in, but
Give me just a moment and I can see if that might be possible. Again, my apologies. This was my error.
Did have an idea.
yes.
Can't get her. Says she's gonna vacate by 119. If we just
said it.
adjourn it to like 120 or 125, they could just dismiss the whole matter. If she's out.
But Mr. Bach has a resolution.
Mr. Bach, sorry. I actually expect her to be out today or tomorrow. We set it for the 10-day deadline, so we could actually adjourn it probably even sooner than that. Because I do expect her to be out probably today or tomorrow, if that could work.
Yes.
For support.
As long as she gives notice and turns in her keys, then it looks like they're willing to dismiss the case outright against both.
Sounds good. I don't know if I have a date sooner, but we'll set it out and you all can file the necessary paperwork.
Thank you, Your Honor.
No problem. Let me get you the date.
Add a slot, January 21st at 3.
At 3? Yeah. January 21st at 3.
Thank you.
Wait, we do here into the morning.
Yeah, we have arraignments that day, but if
Oh, we do.
dismissing it.
Got it. Sounds good. Okay, you're all set.
Thank you.
Thank you, Judge.
Thank you.
That works.
What did I just do related? Interaction. Okay, this is Malik Baller versus Dakita Brown, 25-06878.
Yes.
Appearance, counsel.
Good morning, Your Honor. Robert Ackerman, attorney for the plaintiff.
Your name, ma'am?
My name is Dakita Brown.
Okay, today was the date scheduled. This was for a hearing for non-payment of rent. Looks like the parties have resolved this by a conditional dismissal. The case will be dismissed today, ma'am, upon the condition that you pay $4,711. That's correct?
Yes.
And that's for your rent that accrued through the end of December 31st, 2025.
Yes.
It says defendant to pay balance plus January, February, and March rent on or before March 31st, 2025, correct?
26.
It says 2025. Oh, I'm sorry.
That's mine.
Okay.
2026. You are correct. Okay, and so that's what you want to do, ma'am?
Yes.
And you understand that you have the right to have an attorney represent you today?
Yes.
So you want to waive that right?
Yes, I do.
You also have the right to proceed to a trial or a hearing. You could have demanded a jury trial as well. You understand that?
Yes, I do.
And you wish to waive that?
Yes, I do.
Is anyone coercing you to enter into this agreement?
No.
Anyone threatening you to get you to give up your rights?
No.
You have 3 business days to return to the court to request to have this agreement set aside. If after you leave here, you realize you misunderstood your rights, okay?
Yes.
Also, your partial performance will not satisfy this, so partial payment could subject you to getting evicted. So it says here that you're gonna pay your balance plus your rent. And you're gonna do it by March 31st.
Yes.
If you don't do that, or if you're not compliant with either paying your rent or paying on the balance, the plaintiff can request to have a judgment entered against you and have you evicted. You will not get a new court date. Do you understand that?
Yes, I do.
Do you have any questions for the court?
No, I do not.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
Okay, you're all set. Thank you.
Thank you.
So I didn't think we would run into that a couple times.
What you running into?
The shield about to dislocate my shoulder.
get workers' comp from running into the shield. You wouldn't be able to tell people outside. You're gonna have to say you was taking a defendant down.
Right, something.
Things got wild. You're not gonna be able to say you got injured by the glass shield.
Say what my man has said, his president.
Right. He was adamant that Puerto Rico was not a part of the US. He was very adamant about it. That's unfortunate. That's okay, we're just waiting for one more? No.
What he's up there on his,
We
man.
did that one. We're waiting for, no, we did that one. Ooh. Gunny versus Ariel Tucker. I think.
Yeah, that's
And Bonk is on that one, correct? Which of the piece? I'm not following it. How is it? D&K Rentals LLC versus Dave Hingenbach. Hingenbach, thank you. 25-07246, appearance, please.
Good morning, Your Honor. Norman Woody appearing on behalf of the plaintiff, D&K Rentals.
Okay, and I have Dave Hingenbach, present in the courtroom without an attorney, correct?
Yes.
Okay, this matter is resolved, it looks like with a consent order of conditional dismissal. It says here, the case will be dismissed upon the condition that you pay the past due rent plus court costs for a total $4,487.90, and that's for rent due through a period of the end of this month, correct?
Yes.
And that you shall pay $1,300 every month commencing February 5th, 2026, and continuing on the 5th of each month until paid in full.
Yes.
It says payments will be applied first to the current month's lease and charges and then to the arrearage. That's accurate in your understanding of how you're going to proceed?
Yes, ma'am.
You understand that you have the right to have an attorney represent you during this eviction proceeding?
I did.
Okay, you want to waive that right, correct?
I will, yes.
And you also have the right to proceed to a trial. You could have had a hearing today. You understand that? You want to waive that right as well?
I will.
And no one's coercing you to enter into this agreement, are they?
No.
Okay, you understand that partial payment will not satisfy this, so you gotta do exactly what you say you're gonna do, making your payments on time, otherwise judgment can enter against you and you could be evicted without another hearing, you understand that?
I do.
You have 3 business days to return to the court. If you later realize you misunderstood the rights that you've given up, you can request to have that set aside and then explain to the court how it was that you misunderstood your rights, okay?
Yes.
Do you have any questions at this time?
Do that.
Any additional matters for the record?
No, that's further, Your Honor. So next questions. Oh. I'm sorry.
We have attorneys on both sides too, so.
Okay, this is Gunny Properties LLC, Lansing Dream Home versus Ariel Tucker, 25-06905 LT, appearance please.
Good morning, Aaron Rombach here for the plaintiff.
And good morning, Your Honor, Veronica Pereira on behalf of Ms. Tucker.
As well. Thank you. Today's the date, you can remain standing. Today's the date and time set for a hearing. This was for non-payment of rent. And I have a conditional dismissal. It says here that the parties are agreeing for the matter to be dismissed today upon the condition that you, Ms. Tucker, pay the past due rent plus court costs for a total of $6,741.10, correct? And that's for your rent due through a period of January 31st, 2026, correct? It says the defendant shall pay $1,500 by January 19th, 2026. The defendant shall pay accruing rent of $1,000 each month by the 4th, starting February 4th. Defendant shall pay an additional $541 towards the arrearage by the 15th, starting February 15th. Late fees are waived as long as defendant is in compliance with this agreement. Whoever wrote this can write extremely small. I mean,
'Cause I have my
I have never
glasses on.
seen anything this small before in my handwriting.
Would you like to borrow these?
Wow, no, I have perfect eyesight, actually. Landlord and tenant shall enter into a new lease renewal for 12 months is the additional terms, correct?
I usually put something in there until the balance is zero and current. which I forgot to put in there.
You usually, but you didn't put that. You want to add that is what you're
I think
saying?
we should put that, otherwise when does this end? I
Oh,
mean, it's
yeah,
kind of a given,
right, yes.
but yeah, till the balance is zero and current on the 541.
Oh, okay.
Oh, just that the 541 is not, the additional 541 isn't forever. It's just until the balance is paid off.
Until you're back past your
Yeah,
balance.
and
is
if
paid.
you come in with some money paid off early, then this is satisfied.
Okay.
And we'll go back to normal.
You understand that? I did add until zero and current on the language, okay?
Thank you, Judge.
No problem. And so, ma'am, you understand your right to have an attorney represent you, correct? Okay, you are represented by legal services, correct? Okay, and so you also have the right to have a trial. You've been demanded a jury trial in this matter. You understand that? And you want to waive your right to trial? Okay, no one's forcing you to give that right up, correct? Anyone threatening you to get you to enter this consent order of conditional dismissal? Okay, and you understand that partial payment will not satisfy this, so you got to do just what you say you will do here unless you pay it off earlier.
Yes.
Otherwise, if you don't, judgment can enter against you and you can be evicted without any additional hearing in the court. You understand that? You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your right that you waived, which is your right to a trial, you can return to the court and request to have that set aside, okay? Do you have any questions at this time? Any additional matters for the record?
No, thank you, Your Honor.
Thank you, Judge.
No problem. We'll get you a copy.